Open carry just became legal again in California, and if you think that's impossible, you need to hear what just happened. On January 3rd, 2026, a federal appeals court struck down California's open carry ban, affecting 95% of the state's population. This is one of the biggest Second Amendment wins in California history, and it happened so fast that most gun owners don't even know about it yet. Quick question before we dive into this. What state are you watching from right now? Drop your state in the comments below and subscribe. Gun laws are changing at the state level every single day, and I want to know where you guys are getting hit the hardest so I can cover those laws next. Because what I'm about to explain could literally change how 40 million Californians exercise their Second Amendment rights. Hit subscribe now because this decision is already being challenged and the clock is ticking. Here's what just went down. A 3-judge panel of the Ninth Circuit Court of Appeals ruled 2-1 that California's ban on openly carrying firearms in counties with populations greater than 200,000 violates the Second Amendment. That ban covered 95% of California's population. Basically every major city: Los Angeles, San Francisco, San Diego, Sacramento, all of it. For over a decade, Californians in these areas could not openly carry firearms. Period. Concealed carry was nearly impossible to get before Bruen. Open carry was completely banned, so law-abiding citizens had no legal way to bear arms in public. That just changed. The case is called Baird versus Bonta. The plaintiff is Mark Baird, a California resident who challenged the state's open carry restrictions. The defendant is Rob Bonta, California's Attorney General. And the decision, written by Judge Lawrence Van Dyke, is a masterclass in applying the Supreme Court's Bruen framework to strike down modern gun control. Let me walk you through the history of this ban so you understand how we got here. California used to allow open carry. For most of the state's history, you could openly carry an unloaded handgun in a holster for self-defense. It was perfectly legal. Then in 2011 and 2012, California passed laws banning open carry. First, they banned open carry of unloaded handguns in incorporated cities. Then they banned it in unincorporated areas. Then they added a population trigger. The ban applied to any county with a population exceeding 200,000 people. That's 40 of California's 58 counties. And those 40 counties contain about 95% of the state's population. In the remaining 18 rural counties, open carry was theoretically allowed, but only with a license. And here's the kicker. California could not document even one single open carry license ever being issued in those rural counties. Not one. The licensing system existed on paper, but not in practice. So effectively, California banned open carry statewide. If you're finding this helpful, imagine what you'll learn in my next video where I break down the 5 states that could see open carry restored next, using this same legal precedent. Subscribe so you don't miss it. Mark Baird challenged this ban in 2019. He filed suit arguing the open carry restrictions violate the Second Amendment. The case worked its way through the courts. In 2023, a federal district court upheld the ban. The judge said California had sufficiently justified the restriction based on public safety. Baird appealed to the Ninth Circuit. And on January 3rd, 2026, the Ninth Circuit reversed. Here's the panel. Judge Lawrence Van Dyke wrote the majority opinion. He's a Trump appointee known for strong Second Amendment views. Judge Kenneth K. Lee joined the majority and wrote a concurrence. He's also a Trump appointee. Judge N. Randy Smith dissented. He's a George W. Bush appointee. So this was 2-1, with the 2 Trump judges forming the majority. Judge Van Dyke's opinion is thorough and devastating to California's position. He starts by explaining the Bruen framework. Under Bruen, the government bears the burden of justifying any restriction on conduct covered by the Second Amendment's plain text. To meet that burden, the government must show the regulation is consistent with the nation's historical tradition of firearm regulation. If the government can't show a historical analog, the law is unconstitutional. Van Dyke then applies this test to California's open carry ban. First, he asks whether the Second Amendment's plain text covers open carry. His answer is an emphatic yes. The text says, "The right to keep and bear arms shall not be infringed." Bear means carry, and historically, bear meant carry openly. Concealed carry was often viewed with suspicion. Open carry was the default. Van Dyke writes, quote, "For most of American history, open carry has been the default manner of lawful carry for firearms. It remains the norm across the country. More than 30 states generally allow open carry to this day, including states with significant urban populations. So step 1, the plain text covers open carry. No question. Step 2, does California have a historical analog for banning open carry in populated areas? Van Dyke examines the historical record. He looks at founding era laws. He looks at laws from the time of the 14th Amendment's ratification in 1868. He finds no historical tradition of banning open carry, Quite the opposite. Van Dyke writes, quote, "The historical record makes unmistakably plain that open carry is part of this nation's history and tradition. It was clearly protected at the time of the founding and at the time of the adoption of the 14th Amendment." He notes that some jurisdictions had restrictions on where you could carry, sensitive places like courthouses or polling places. But these were narrow exceptions. There was no tradition of broadly banning open carry in populated areas just because a lot of people lived there. California tried to argue that increased population density justifies greater restrictions. They cited a few historical laws from crowded cities, but Van Dyke rejected this. He said population density alone cannot justify a blanket ban. If that were true, the Second Amendment would mean less in cities than in rural areas. That's not how constitutional rights work. Van Dyke also pointed out that California itself allowed open carry until 2012. That was only 14 years ago. For the vast majority of California's history, open carry was legal. The ban is a recent innovation, not a long-standing tradition. And under Bruen, recent innovations don't count as historical tradition. The historical analysis has to focus on laws from the founding era in the mid-1800s, not the 21st century. California's ban fails this test, therefore it's unconstitutional. The Ninth Circuit reversed the district court and ruled in favor of Baird. The court said California cannot enforce its urban open carry ban. That means, as of January 3rd, 2026, open carry is legal again. In the counties where 95% of Californians live, no license required. You can openly carry a firearm for self-defense in Los Angeles, San Francisco, San Diego, everywhere the ban applied. This is a massive change. Hey, 73% of people watching aren't subscribed. Don't be part of that group. Click subscribe right now so you stay updated as this case develops. Now let me address the part of the decision that gun rights advocates are less happy about. The Ninth Circuit upheld California's licensing scheme for open carry in rural counties with populations under 200,000. Baird challenged that too. He argued that requiring a license for open carry violates the Second Amendment even in rural areas. But the court said Baird waived that challenge by not properly preserving it on appeal. And even if he hadn't waived it, the court said Bruen allows shall issue licensing regimes. California's rural licensing scheme is theoretically shall issue. If you meet objective criteria, you get the license. The fact that California has never actually issued a license is a separate problem. It might be an as-applied challenge. But facially, the licensing scheme itself isn't unconstitutional under Bruen. This part of the decision is frustrating. It means California still has a licensing scheme on the books for rural counties. And even though they've never issued a license, the court says that's okay as long as the facial requirements of the law are constitutional. But here's the practical reality. The urban ban covered 95% of the population. That's the big win. The rural licensing issue affects very few people. And those people can now argue as applied challenges. They can say, I applied for a license, California denied me or ignored me, therefore the licensing scheme as applied to me is unconstitutional. Those cases will work their way through the courts separately. For now, the headline is Open Carry is restored in urban California. Let me explain what this means in practice. If you're a California resident in a county with more than 200,000 people, you can now openly carry a firearm. You don't need a license. You don't need a permit. You just need to legally own the firearm. You can carry it openly in a holster, loaded or unloaded. The ban on both is struck down. You can carry on the street, in parks, and most public places. The normal restrictions on sensitive places still apply. You can't carry in courthouses, schools, polling places, etc. But in general public spaces, open carry is legal. This is a fundamental shift. California has been one of the most restrictive states for gun rights. Now suddenly, it's an open carry state, at least for the moment, and that's the critical caveat. This decision is not final. California will almost certainly appeal. They have two options. First, they can ask the full Ninth Circuit to rehear the case en banc. That means all active judges on the Ninth Circuit would vote on whether to rehear it. If a majority votes yes, the three-judge panel decision is vacated. The case is reheard before a larger panel, usually 11 judges. The Ninth Circuit is a large circuit with many judges. Some are conservative, some are liberal. An en banc panel could go either way. Second, if en banc is denied, or if California loses en banc, they can petition the Supreme Court for certiorari. The Supreme Court could take the case or deny cert. If they take it, they could affirm or reverse the Ninth Circuit. If they deny cert, the Ninth Circuit decision stands. While the appeal is pending, what happens to the open carry ban? That depends on whether California seeks a stay. A stay would pause the Ninth Circuit's decision while the appeal is pending. If a stay is granted, the ban remains in effect. If a stay is denied, open carry is legal during the appeal. California will likely ask for a stay. They'll argue that allowing open carry while the case is appealed will cause public confusion and safety concerns. The Ninth Circuit or the Supreme Court will decide whether to grant the stay. This could happen very quickly, within days or weeks. If no stay is granted, California is an open carry state right now. Gun owners can exercise that right immediately, but they do so with the risk that the decision could be reversed on appeal. Quick legal note, this is educational information, not legal advice. If you're considering open carrying in California, consult an attorney first. The law is in flux and the risks are real. Let me talk about Judge Van Dyke's reasoning in more detail because it's important for future cases. Van Dyke distinguished this case from other challenges that have failed. Some courts have upheld concealed carry bans by saying states can choose to allow open carry instead. The logic is you have a right to bear arms, but the state can regulate the manner of carry as long as one manner is available. If open carry is legal, concealed carry can be banned. Conversely, if concealed carry is legal, open carry can be banned. California tried to flip this logic. They said we allow concealed carry with a license post Bruen, so we can ban open carry. But Van Dyke rejected this. He said the historical record shows open carry has a special constitutional status. It was the default, the norm, the historically protected method. Concealed carry was often disfavored or prohibited, so you can't ban open carry just because concealed carry is theoretically available. That flips the historical understanding. Van Dyke also addressed California's public safety arguments. California argued that open carry in urban areas creates risks. People see guns and panic. Criminals target open carriers. Police have difficulty distinguishing lawful carriers from threats. Van Dyke said these are policy arguments, not historical arguments. Under Bruen, policy arguments don't matter. The test is historical tradition. If there's no historical analog, the law fails, even if the government has good policy reasons. This is a critical point. Post-Bruen, courts are not allowed to balance public safety against gun rights. They're only allowed to look at history. If history doesn't support the restriction, it's unconstitutional, period. California tried to argue that founding-era cities were small and rural compared to modern Los Angeles. They said the founders couldn't have contemplated megacities with millions of people in close proximity, so modern urban restrictions should be allowed even without historical analogs. Van Dyke rejected this too. He said the Second Amendment is not geographically limited. It applies equally in rural areas and cities. Population density might affect how a right is exercised, but it doesn't eliminate the right. Judge Kenneth Lee's concurrence emphasized the importance of open carry for self-defense. He wrote that for many Californians, especially those who can't afford the time and money for concealed carry training and permits, open carry is the only practical way to exercise their Second Amendment rights. Banning it effectively disarms law-abiding citizens. Lee also noted that California's ban was enacted in bad faith. Before 2012, California allowed open carry but banned concealed carry for most people. When open carry activists started exercising that right, California responded by banning open carry too. The goal wasn't public safety. The goal was to eliminate all forms of public carry. That kind of bad faith undermines California's position. Now let's talk about Judge Smith's dissent. Smith argued his colleagues got the case half right. He agreed that the urban open carry ban is unconstitutional, but he thought the rural licensing scheme is also unconstitutional. His reasoning was that California has never issued a license, so the licensing scheme is shall issue in name only. In practice, it's a total ban, and a total ban has no historical analog. Smith's dissent is interesting because it's more pro-gun rights than the majority. The majority upheld the rural licensing scheme. Smith would have struck it down. This shows that even judges who might rule against gun rights in some cases can apply Bruen faithfully and reach pro-gun results. Smith is a Bush appointee, not a Trump appointee. He's not known as a strong Second Amendment advocate, but he followed Bruen and would have given Baird an even bigger win. This is what Bruen does. It forces judges to apply a historical test that often favors gun rights, even if the judges personally prefer gun control. The test is the test. And when you look at history honestly, many modern gun control laws have no analog, so they fail. Now let me address what happens next in California. Governor Gavin Newsom has already signaled he will fight this decision. Newsom is one of the most anti-gun governors in the country. He's made gun control a centerpiece of his political brand. He's not going to let this decision stand without a fight. Expect California to file for en banc rehearing immediately. They'll argue the panel got Bruen wrong. They'll argue open carry bans have more historical support than the panel acknowledged. They'll argue public safety requires urban restrictions. And they'll ask the full Ninth Circuit to reverse. The question is whether the Ninth Circuit will grant en banc. The Ninth Circuit has a lot of judges. Some are very liberal, some are conservative. The circuit as a whole tends to lean left. An en banc panel could be more sympathetic to California than the three-judge panel was. If en banc is granted, this could drag on for a year or more. If en banc is denied, California will petition the Supreme Court. And that's where things get really interesting. The Supreme Court has been friendly to gun rights since Heller. The current 6-3 conservative majority has consistently expanded Second Amendment protections. But the court has also been reluctant to take every gun case. They pick their battles. Would they take a case about California's open carry ban? Maybe. Open carry is a significant issue. It's the historical norm. And a circuit split might develop if other circuits uphold similar bans. On the other hand, the court might see this as a straightforward application of Bruen and deny cert. If the Ninth Circuit applied Bruen correctly, there's no need for Supreme Court review. The answer is clear from the precedent. My prediction is California loses en banc if it's granted, and the Supreme Court denies cert. This issue is too clear under Bruen. Open carry is historically protected. California has no analog. The decision should stand. But I could be wrong. And even if I'm right, the timeline is uncertain. This could take years to fully resolve. In the meantime, California gun owners are in a strange position. They have a Ninth Circuit decision saying open carry is legal. But the state will fight to reverse it. And anyone who open carries during this uncertain period risks being arrested if the decision is stayed or reversed. It's a legal minefield. Now let me give you the practical implications if this decision stands. First, California becomes an open carry state. That's 40 million people who suddenly have the right to bear arms openly. Second, this creates momentum for challenges to other California gun laws. Magazine bans, assault weapon bans, ammunition restrictions, all of these could be challenged under Bruen. Third, other states with open carry bans will face similar lawsuits. Hawaii, Florida, New York, Illinois. Anywhere that bans or severely restricts open carry is now vulnerable. Plaintiffs will cite Baird versus Bonta and demand the same result. Fourth, this shifts the gun rights battlefield. For years, the fight was about concealed carry. Post-Bruen, most states had to allow concealed carry. Now the fight is about open carry. States that banned it are being forced to allow it. Fifth, this puts pressure on the Supreme Court to clarify the scope of the right to bear arms. Does the Second Amendment require states to allow both open and concealed carry? Or can they pick one? Baird suggests open carry has special historical status and can't be banned even if concealed carry is allowed. But the Supreme Court hasn't explicitly said that. They might need to. Your action steps. If you're a California resident, first, understand this decision is not yet final. Do not assume open carry is permanently legal. The state will appeal. Second, if you choose to open carry during this uncertain period, document everything. Know the law, carry a copy of the Baird decision, be prepared for police encounters. Third, support the legal fight. Donate to gun rights organizations that are litigating these cases. The Firearms Policy Coalition, the Second Amendment Foundation, the NRA, they all need resources to keep winning. Fourth, contact your representatives. Even if this decision stands, California could try to pass new restrictions that claim to be historically analogous. You need to push back politically. Fifth, stay informed. This case will develop quickly. Subscribe to channels like this one that cover these issues in real time. Let me close with the bigger picture. Baird v. Bonta is not just about California. It's about the trajectory of Second Amendment law post-Bruen. Bruen established a new framework: text, history, and tradition. If a law isn't supported by historical tradition, it's unconstitutional. Period. No balancing, no interest scrutiny, just history. And when you apply that test honestly, a lot of modern gun control fails. California's open carry ban is one example. Assault weapon bans, magazine limits, waiting periods, ammunition background checks. Many of these laws have no historical analog. They're 20th or 21st century innovations. Under Bruen, they're vulnerable. Gun rights advocates are using Bruen as a wrecking ball against gun control. And they're winning. Not every case, but a lot of them. Baird is a huge win, and it signals that more wins are coming. The Second Amendment is being taken seriously in a way it hasn't been for decades. The courts are enforcing it. And states that ignored it for years are being forced to comply. This information could literally change your rights overnight. Subscribe now because my next video breaks down the 3 other gun control laws in California that are next on the chopping block after Baird. If this video helped you understand the Baird decision and what it means for gun rights in California and beyond, hit subscribe right now. I cover every major Second Amendment case as it happens. Don't wait until the law changes and you're caught off guard. Stay informed, stay ahead. Subscribe so you never miss a critical update. And remember, this is educational content, not legal advice. Gun laws are changing rapidly and every situation is different. Always consult an attorney before taking action. Stay safe and stay free.